Thank you. Please be seated. And good morning. We have 4 cases that will be submitted. Those cases are State of Iowa versus Sean Gordon, State of Iowa versus Montez Guys, State of Iowa versus Mitch Busing, and the final case is David Evanson versus Winnebago Industries, Inc. and Century Insurance Company. The last 2 cases are now submitted to the court without oral argument, and will proceed to hear the arguments in the Gordon case. Ms. Hines.
May it please the court. The Court of Appeals majority in a 5-4 en banc decision reversed Gordon's sentence. It erred in deciding an issue not raised by the parties, but perhaps more consequentially, it erred in the manner in which it decided that issue, which was in its finding that risk assessment tools may not be considered by the district court because they're not expressly authorized by statute. Both the code and Iowa case law have provide the sentencing court with wide.
Before you get into the merits of the case, tell me about air preservation. I mean, there was no objection to the pre-sentence investigation.
That's correct.
The gentleman was sentenced, and all of a sudden, in appeal, we get all these issues raised. What's the state's position on that?
The state's position is that to get into the meat of the issues, the defendant was required to object when he was offered an opportunity at sentencing to the pre-sentence investigation report. And by not objecting, we don't have a record to help us understand the purpose and get into more thoroughly the use of the static 99 and SOTIPS actuarial instruments. The state.
Is this an ineffective? This is a counsel standard, or is this a
at this point? It's the Court of Appeals dissent is what I'm relying on in saying that error was not preserved, and if error is not preserved, then yes, ineffective.
This old Iowa case, though, I think it's Young that says that if there is a impermissible sentence, impermissible sentencing factor used, you need not object to it, and error is automatically preserved on that. How do you get around that, then?
I think that factor is not contained in the PSI. My understanding is if it's something before the defendant is offered the PSI to object to, and if it's something that's outside of the PSI that the district court did improperly, he didn't have an opportunity to reject.
Do you have any authority for that?
Pardon me?
Do you have any authority for that?
Granberry, I think, is the authority for that. State v. Granberry.
What do you make of the Court of Appeals majority footnote? And that says something to the effect that, well, if the defendant's race had been identified in the PSI, ordinarily one wouldn't object to that, although consideration of race would obviously be improper. It's in the PSI, but it's a true fact, and the footnote, as you know, basically said, well, this is kind of similar because these scientific workups supposedly are not to be used in sentencing. Anyway, you know what I'm referring to.
Yes, I do. And these assessment tools are not the same as race or gender or religion.
But did they have I guess to put a sharper point on it, was there an expectation that it wouldn't be used because the tools expressly are designed to be utilized for planning purposes in DOC, but they're not designed to be used in sentencing? At least that's how I read the footnote. Maybe you read it differently.
Well, I also read the footnote as inconsistent with that air preservation argument because it implies that it might be permissible if you objected, or it might be preserved if you objected, but then it says something about how you would need to put on more evidence to show that it was permissible. And it's either impermissible or not, but there's no way in which an impermissible factor could be saved by providing more evidence.
Apart from not objecting, did he affirmatively consent to use of this test?
He did. He consented by participating in the assessment itself He was told, explained the purpose of the assessment, and he was given a chance not to participate, but he did. And then he specifically did not object to the assessment at sentencing when asked.
What was he told on the purpose of the assessment?
What was he told the purpose? I think it was for his chances of reoffending. I think he was told exactly that for the static 99, and that it would also help with his treatment needs.
Was he informed that it would be a factor in his sentencing?
I don't know for sure, but I think that's probably understood when you're participating.
Would it matter, I guess, is that I'd come back? I mean, one could argue, well, yeah, he was told. I mean, he wasn't told that the judge was going to be considering it. He wasn't expressly told. We'll check the record.
You're
But
right. Yeah.
my recollection, which could be not quite right, but my recollection is that he was not specifically told it would be used in sentencing. Now, maybe one could argue that the context matters. Or one could say, well, he knew, he just didn't know that the judge was going to be considering what he, how he responded.
Well, it's hard to imagine he wouldn't know when he's answering questions in the PSI regarding his employment history or his health history or substance abuse history, and then he participates in this test. It's hard to imagine that he wouldn't understand that that was for the
Is there a
purposes.
problem in using employment history when African Americans, for example, have a higher unemployment rate? I mean, we see this in the literature. One of the attacks of these kind of formulaic studies is that they end up locking in disproportionate treatment. Do we have a problem with that here?
I don't think it does. For one thing, these particular instruments, I don't believe consider employment. It's considered in the broader PSI, but these instruments don't consider employment opportunities and so forth. But the codes 901.2, 901.5, even 907.5 provide the district court with the ability to consider any relevant or pertinent information. And again, our case law supports that, those statutes, because it encourages courts to gather and consider as many things.
Why is an actuarial study pertinent to an individual's propensity to reoffend?
Well, it's a piece of information about that individual's who compares favorably to people who have also received that risk score. And that is explained in the static 99, that this is not a risk assessment that says that this defendant is at high risk. It says this defendant is like those people that are high risk of reoffending. So it's general information that's relevant to this defendant's risk, if that makes sense.
If we hold these, this risk assessment cannot be used at sentencing because you shouldn't be able to extrapolate from the general to population in those studies to an individual defendant, what impact would that have on the use of risk assessments for pretrial release?
It would create a problem, because that's something that these evidence-based informational studies are helpful in making these decisions, and that's the nature of them. And I think the dissent points out we are now very accustomed to seeing these kind of actuarial instruments used in the pretrial release case and the sexual predator commitment cases. They are to be used as a helpful guide to the courts in making release decisions and sentencing decisions.
Last session, I'll get this right. Last session, the legislature passed a law that you couldn't use risk assessment for pretrial relief. Governor vetoed it, of course, but doesn't mean they may not enact it next session. If they enact such a law that you can't use these assessments, does that have any bearing on on the posture of the case?
I think
the future?
it would provide support for the argument that they should not be used. I don't think it would necessarily translate to their use at sentencing.
Let's take a look at the Loomis case briefly, if we can. And I want to net out the fact that this compass was not transparent. That's a curious thing. we don't have here, I don't believe. But Loomis, as I understand it, indicated that a written advisory was required for these type of studies, and I think there were 4 prongs to it, that it involves group data, that there may or may not be validation studies, the purpose of the tool, the extent of disclosure. It's the 4-pronged kind of Miranda-type disclosure almost, written disclosure. Now that did not occur here. What do you make of the Loomis 4-pronged disclosure requirement, and whether we should go in that direction here?
Well, and that, of course, was the original issue briefed by the parties, is whether the defendant's due process rights were violated because these warnings and cautions were not included with the risk assessment. I think some of them were. But in Loomis, they affirmed the defendant's conviction and sentence, even though they weren't there in that case, and they have subsequently, in State v. Jones, I believe it was, coming after Loomis, they have affirmed sentences that did not have that, contain that information. It appears that this is more.
But State versus Loomis was in effect, since it's a counsel where the judge testified, I would have sentenced the person the same way without the compass.
True.
So, I mean, how can that argument be sound then? Because it's a different posture.
It's a different posture, but I think that we can understand from the subsequent cases that followed Loomis that the information is something that the district court, or the Supreme Court has it's more of an advisory caution, I believe, and that they have affirmed, they have not found due process violations because of the absence of cautionary.
It was like, is dicta or just kind of some suggestions in the Loomis court?
I think that's how I read it, because again, the cases that follow that affirm sentences that have used the compass without that kind of caution and limitation.
Am I correct that if we were to determine that the Supreme Court's going to say perhaps district courts don't be using that anymore, you can't consider it, am I correct that the Department of Corrections may very well continue to use it as a tool in their preparation of the PSI?
Yes. In fact, and that's one of the notes that the dissent note, one of the dissent's notes in the dissent in Geis, which is that the transparency component will be affected if we can't list them in the PSI, but the district court might know about it, and also that these decisions are being made for other purposes than sentencing, but they're helpful in sentencing as well. But there's a case, State v. Lawson, that came after Gordon v. Geis, and the affirmed sentence, although the district court had seen in the PSI a risk assessment result, but they said that because the district court didn't mention it in its reasons for sentencing, it was not an error. So what it creates is a problem of this evidence exists out there, but the district court can't talk about it. And that leads to less transparency.
Wouldn't that be true? There's perhaps other things that comprise the PSI that the court may not even be aware of, tools that Department of Corrections uses in formulating that final report that comes to the court?
Absolutely. Absolutely. So to find more transparency, it's better to just say that this is something the district court is fine to consider it. It's a piece of the analysis of whether a defendant should be sentenced or put in place on probation. But in this case, and this is important for the cases cited by the defendant in its due process claim, it was not the only factor. It was not the determining factor. The district court, as the dissent put it, did an exemplary job of listing its reasons, which are quite extensive, for imposing sentence in this case. And of course, it could never be one factor just under our current law, but it certainly was not even close to being one factor in this case. The other thing that evidence-based instruments such as this do favorably is create objective bases from which to consider defendants and more uniformity, so that the district court, any implicit bias that they might have is informed by these kinds of instruments that reveal in general how somebody like the defendant, what their risk of reoffending is. So, both in transparency and in fairness and in uniformity, these tests are important for sentencing. And they are relevant and pertinent under the statute.
What happens on remand under the Court of Appeals decision? It refers to on this state of the record. Does that allow the state at resentencing to make a record on the validity of the risk assessment?
That's how I read it, although again, it doesn't quite make sense. If it's an impermissible factor, then what record could you make to make it permissible? The other aspect of that I just would note is that if a record can be made, now in every sentencing, and we've had a few already come up in district courts, are we gonna ask the Department of Corrections to come in and testify at sentencing about the validity of these risk assessment tools? In particular, may it please the court, the state respectfully requests you affirm the district court sentence in this case.
Ms. Hines, thank you. Ms. Lucey?
Before you get to the merits, let's talk about air preservation. Why, is this an ineffective assistance counsel case, or is this a direct appeal case? The Court of Appeals decided on direct appeal, an issue that may or may not have been raised. I mean, to try to avoid the constitutional issue, they made their own issue, it seems like. But depending on how we review it, I think depends on what we do with the case, and I think that's important. And tell me why, when your client does not object to anything in the PSI report, that it's not ineffective assistance of counsel, as Loomis was ineffective assistance of counsel. When you read the PSI statute, statute 901.4, it requires that a defendant file before the court any objections or any refutations of anything contained in the PSI report, which it seems like our district courts don't follow, and it seems like everybody's avoiding the language of the statute. Does Granberry really apply when we have a statute that says what the proper procedure is?
Also, it seems to me there's another model of looking at this case, and that is the proper posture would be to be an objection, and then have a Daubert-type challenge. There's a rich literature attacking the 99R, the static and somewhat dynamic 99R. Because the database is, not from the local jurisdiction, and there's all kinds of Daubert-type challenges. Same is true with all the other tests. If there would have been an objection and an opportunity to develop the expert testimony and I mean, garbage in, garbage out, if you do consider unemployment, you do consider housing and et cetera, that's gonna skew it in a racially discriminatory manner, et cetera. Maybe evidence sustains it, maybe it doesn't. But wouldn't we be better off deciding this kind of case in the context of a full-blown adversary hearing on the reliability of these tests, and then the district court would know what the shortcomings of the test are and the strengths of the test, and decide what weight to give it. But usually we have the adversary does that. I mean, so the state wants to use the statistical actuarial study, and then it's the job of the challenger to come forward with, in this case, it would probably require expert testimony, and to show the shortcomings of the evidence.
But let me ask this, if I read the rule on PSIs, or the statute, 901.4, you're not supposed to include the mental health exams in the PSI unless either party requests it. Here it was included in the PSI. Did either party request it, or was it just gratuitously thrown in there?
Ms. Lucey, I'm gonna have to ask you to pull that mic even closer. There you
How
go.
about if I try to move?
Yeah,
Does that work better?
just pull it as close as you can, thanks.
Neither party requested, as far as I understand.
And when I read the PSI, it does have the limitations of the static 99 in there. It says that it's based on groups, it's not this guy, blah, 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 blah. What more do you need to put in there when the report's included and it talks about all those things?
And then with the SOTIPs, it doesn't include any of that information. And the district court clearly didn't understand what the purpose of the SOTIPs was. Because in sentencing Mr. Gordon, the district court said, this tells me what we should expect of your progress and treatment, which is totally incorrect.
Well, it does say it's to monitor treatment and assessing treatment needs. I mean, it's right in there what it's for.
Correct,
They
but
have the explanation. The judge had the explanation.
But that's not what the judge believed it was. So there's the incorrect information. Because if you look at the SOTIPS manual, which is very clear, that is something that is given every 6 months to monitor progress. And within the SOTIPs, there are questions related to housing, and you actually get a higher score if you're dissatisfied with where you live but can't afford to move.
I think that was disclosed if you read the last page of the pre-sentence investigation. It says, SOTIPS, the Sex Offender Treatment Intervention and Progress Scale, is 69 statistically derived dynamic measure designed to aid in assessing risk, treatment, and supervision needs and progress among adult male sex offenders. The risk and factors include it has that information in there, and the court had it.
The court had what the factors were, but not what the scoring is and what that means. And the court didn't have that this is an ongoing test for progress. It doesn't mean this is what the progress we expect you to have right now, because that's not what it means. And so when we look at Loomis, they actually had the warnings in the PSI. Wisconsin DOC actually includes those. So if you look at paragraph 15 of the Loomis opinion, it says the PSI told the district court these things. So when we say Loomis wasn't a due process violation, that is because they had those cautions and limitations. Wisconsin Supreme Court went farther and said, these are the things that have to be included in order for the court to consider them. Jones was a no-merit brief, an Anders basically, and what it said was, we follow Loomis, because it was the Wisconsin Court of Appeals. Loomis had already set the guidelines. We then look at what happened in the U.S. Supreme Court with Loomis, and cert was denied after the Solicitor General filed their brief indicating that that was a poor vehicle to decide this for two reasons. The cautions and limitations were in the PSI, so there was not the due process violation, and no other state courts, highest courts, had addressed this issue, which is what we're asking this court to do now.
You didn't brief this issue, but is it your position that the risk assessments are improper factors to use in sentencing, blanketly? Or is your argument using them could be a due process violation if certain things are done? Because you argued the due process in your brief.
Okay. In this case, I argued that it was the due process violation. If you then look at if the court does not want to reach the constitutional issue, you can then go to the abuse of discretion.
Is it abuse of discretion for a court to use these risk assessment factors, and why?
Yes, because this is an off-label use. If you look at the risk assessment instruments, and I'll stick with the static 99 and the SOTIPs, what we have is the court is considering these actuarial instruments.
No, they're off-label uses without having some kind of hearing. It's not in the record they're off-label uses.
These are public instruments. So
Every time a court has something in a pre-sentence investigation that they're not familiar with, they're going to have to go do all the background information and do their own investigation as to what's good and what's not good before they could sentence somebody. Is you're telling us that it's required of a district court judge?
I'm saying that the district court judge could have a shortcut from the PSI that tells the district court the relevant information, that SOTIPs is not normed for an Iowa population. It is normed on Vermont, that the static 99R is not normed on an Iowa population, that it is normed on Canadian. The original static 99 was normed on Canadian and the United Kingdom. There's been studies in other states and have found that static 99 overestimates risk.
Isn't that the defendant's obligation to bring that information up in objecting to items contained in the PSI, and not the judge to go out and do independent investigations?
It's the responsibility of Department of Correctional Services to provide relevant and accurate information to the district court. If we're going to have these PSIs designed to give the district court information and avoid 3-day hearings, then the Department of Correctional Services should provide this information to show that whether or not things within the PSI are proper and accurate for the district court to rely on. If we have things that are, totally bunk science within the PSI, is the justice system going to think that this is a good idea for us to use?
Isn't the two words anything, relevant or pertinent, those two words are pretty darn broad? Don't you think there's perhaps times that a district court's going to hear things that might be considered offline, but it goes in that category of anything relevant or pertinent? And if the court's allowed to at least consider, the word consider is pretty light. What are your thoughts on that?
I think that pertinent and relevant has to be accurate. And if it's not accurate and the off-label use is such that we're not considering the fact that these instruments don't have any items that judge what the relative risk or the risk predictive for going to prison, incarceration. We don't have any of that. These were designed for supervision, for treatment. And so if you are looking at relevant and pertinent, that would be an important factor to know.
But we use these things to put people in Cusco, whatever the acronym is, We use those for that purpose, and that's actually sending somebody to, well, civil jail, I call it, is what we'll refer to it as.
And they certainly are used within the sexually violent predator to send people to CUSO, but they're not used exclusively.
How about when a PSI includes a mental health evaluation, for example, or reference to it? You can be assured that that psychologist and or psychiatrist has used all kinds of tools in their toolbox to come up with a final conclusion, whether that be a diagnosis or propensity. And that would be incorporated in PSI too. So why is this so different than all the other tools that are used by other experts that help make up a PSI?
A mental health diagnosis is based upon the DSM, I think it's 4R, and it might even be 5. And those are criteria, and it is not about a group. There may be criteria that psychologists, psychiatrists see regularly, but this is about an individual.
But getting back to that pertinent and relevant, you said it had to be accurate. Well, in that example I gave you with a mental health therapist, the tools that they use technically were not made for sentencing.
But they were made to diagnose a mental illness.
Right, just like the PSI assessment tools are perhaps used to assess risk.
They're assess risk for supervision, pretrial release, parole. They're not designed to assess whether this person should go to prison or not. And I'm counting up. May I conclude?
You may sum up.
This case, the district court was not aware of the cautions and limitations, which ultimately led to the ecological fallacy, which is the failure in reasoning that arises from an inference about group data for one individual. I'd ask that this court reverse Mr. Gordon's conviction or sentence, vacate his sentence, and remand for resentencing. Thank you.
Ms. Lucey, thank you as well. Ms. Hines, you may present your rebuttal.
May it please the court? Just very briefly, I wanted to comment about Loomis and Malinchek, which are the two cases that discuss the use of risk assessment tools. In both those states, they have indeterminate sentencing in which the district court can set the length of the sentence. And that's kind of what was key in their holding about the proper use of these decisions or these instruments. Of course, Iowa has, the decision is basically whether to imprison or put somebody on some form of probation. It's not deciding the length of the sentence. So I think that's just important to distinguish those two cases from Iowa. And with that, the state requests.
I have a question, one more question, please. So this is a sentencing proceeding. It's a little procedurally odd in the sense that the rules of evidence don't, directly apply, at least. Earlier, I was asking about hearing with experts and so forth and so on. Is that what we really want to do in these sentencing hearings? I mean, ideally, I guess, we'd have, kind of a battle of experts on relevance and admissibility and norming and so forth and so on. Is that something that the public defender is going to be able to do? Are they going to be able to hire experts?
No, in fact, the cost of the system is going to be enormous if we have to.
Somehow, well, the answer is candid, but troubles me.
Well, not the cost, but what I mean is that you are going to have to call in people that are experts in the field in each sentencing hearing if that is challenged.
But don't they? I mean, if my client is being sentenced, right, and it's in the PSI report, and I object,
I think.
Don't I get the opportunity to get some real expert testimony? And as I think we all know, the literature is full of various viewpoints on these. I'll just characterize it that way, on the actuarial studies. What bothers me is, ideally, I'd like to see a nice fat record with lots of good experts and so forth and so on. And you're kind of telling me I'm not going to get it in the sentencing hearing.
I guess what I would say is that I think that case can come and somebody can raise those issues if they raise them in the district court and explain the merits and deficiencies of these instruments. It's not in this case, and there's nothing to prevent somebody from doing that. But I think that because these are all valid instruments, it would be.
We don't know they're valid instruments, actually.
Well, this.
Might be subject to some kind of dispute.
Any complaint about them could be addressed in the district court. I guess my feeling is that once this is settled, I would hate to see every sentencing turn into a hearing with experts re-deciding whether these instruments can be used properly.
In general, I mean, there's a trend towards risk assessments, right? The American Law Institute, the American Bar Association, the National Center for State Courts, the National Conference of Chief Justices are all advocating for increased use of risk assessments. Are these a good idea?
Yes, they are, because they provide uniformity, and they actually remove any kind of bias, I think, from these considerations, because they are based upon empirical factors that.
Well, but if they include housing and unemployment and financial status, it's going to discriminate against those that don't have those kind of resources. It's going to discriminate against African Americans.
It would depend on the instrument.
Sure would. So actuarial studies may have a place, but they need to be well designed.
True, that I would agree with. But in general, evidence-based instruments are favored by the majority of people who use them or recommend using them, including Justice Cady in his State of the Judiciary talked about the use of these kinds of instruments to get better justice. So with that, the state respectfully requests this court affirm the sentence imposed in this case.
Ms. Hines, thank you. Ms. Lucey, thank you again. The case of State versus Gordon is now then submitted, and we'll next hear the arguments in guise.